Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
We are back on the record today for the 28th Circuit Court here in Wexford County. And this afternoon, we're going to take up the case of People of the State of Michigan versus Tristan Lee Walker. This is case number 25-14105FH. Appearances, please.
Nick Burns on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of and with Tristan Lee Walker. He's joined me at the table.
Thank you. You may be seated. We are here today for an initial pretrial conference. I conducted that in chambers a few minutes ago with counsel. Counsel informed me that they had reached a pretrial agreement and that we would be entering a resolution today on the record. Mr. Carnes, why don't you please state for us that pretrial agreement?
Your Honor, it's my understanding that defendant is going to plead guilty to count 1, possession of cocaine less than 25 grams. And the people will dismiss count 2, disorderly person drunk, as well as the habitual offender third offense notice.
Mr. Harrison, is that a complete and accurate statement of the pretrial agreement?
It is indeed, Your Honor.
Mr. Walker, is that what you understood we were going to do today?
Yes, Your Honor.
To the best you can, please raise your right hand. There you go. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. Mr. Walker, looking back on July 11th of this year, were you on probation, parole, or bond at anywhere at the time? Were you on probation?
No, sir.
Were you on parole?
No, sir.
Were you on bond pending any felony charges anywhere?
No, Your Honor.
Thank you. You are currently charged today on a felony information with 2 counts and a sentencing enhancement. Count 1 is a charge of possession of a controlled substance, cocaine, in an amount less than 25 grams. That's a felony punishable by up to 4 years and or up to $25,000. Plus, there's a third habitual felony offender enhancement that could, within the discretion of the court, increase that potential punishment from up to 4 years to up to 8, and from up to $25,000 up to $55,000 or $50,000. However, if you plead guilty to count 1, that sentencing enhancement will be dismissed and you'll face merely the up to 4 years. You also charged in count 2 with a misdemeanor called drunken disorderly person, which is a misdemeanor punishable by up to 90 days and or up to $500. That charge will also be dismissed. Is that what you understood to be the terms of your pretrial agreement?
Yes, Your Honor.
Now, by entering a plea of guilty, if I accept that plea, you'll not have a trial of any kind and you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have silence used against you, and the right to testify if you don't choose to testify. Mr. Walker, do you understand that if you plead guilty and I accept that plea, you will be waiving those rights?
Yes, Your Honor, I do.
And at least I should have said only as they apply to this case. Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right, which is allowed when someone's convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor, I am.
Now, I have no doubt Mr. Harrison's gone over the Michigan sentencing guidelines, tried to give you an idea or estimate as to how they might score for the minimum end. He's also probably trying to apply his experience and give you an idea as to what he thinks the court would sentence you to. The question that I have, however, is, has he or anyone made any promises or assertions as to exactly what the sentence would be?
No, Your Honor.
I highlight for you any discussion regarding the Michigan sentencing guidelines would merely be an estimate, and the guidelines are not mandatory. They are, however, a very valuable tool that the courts have to use, and we do use. If you understand,
Yes, Your Honor, I do.
do you still wish to enter the plea as we discussed?
Yes, Your Honor, I do.
As to count 1, possession of the controlled substance methamphetamine, how do you plead?
I plead guilty, Your Honor.
Before the court can
Your Honor, it's count 1, possession of cocaine.
cocaine, sorry. Methamphetamine happens so much, it's automatically in my brain.
I didn't
Sorry.
catch it, Your Honor. Thank you.
As to
Mr.
count 1,
Chair.
possession of cocaine in an amount less than 25 grams, which is on the rise here in the community. How do you plead?
Guilty, Your Honor.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turn your attention to July 11th of this year in the village or city of Manton in Wexford County. What happened?
I was in possession of cocaine, stopped and arrested by an officer of law.
Where was the cocaine?
It was residue in a bag in my backpack.
All right, and did you know that was there?
Yes, Your Honor.
And it's because you had some cocaine in it before it became just residue?
Yes, Your Honor.
Could you actually see some of the residue in the baggie? Like it didn't have a film in it?
Yes, Your Honor.
All right, thank you. And did you have in your mind any lawful right to possess that cocaine?
No, I did not, Your Honor.
All right, Mr. Carnes, do you believe he's provided the factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Compliance with court rules?
Yes, Your Honor.
Mr. Harrison, do you agree with all three of those?
I do. I'm suitably impressed with his forthcoming nature. Thank you.
All right. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for that offense. Therefore, the defendant is found guilty of count 1. Count 2 and the enhancement will be dismissed for time of sentencing. We do sentencing on Monday mornings in this court. Anytime someone's convicted of a felony in the state court in Michigan, a pre-sentence investigation report must be prepared by an agent of the Michigan Department of Corrections, which is also known commonly as the probation parole office. There are 3 steps that involve you in the preparation of this report. Number 1, you're going to get a packet that has already been handed by the clerk to the bailiff. You're going to open it up, follow the instructions, complete it, turn it in. Number 2, you'll be subject to an interview with an agent from that office, and you have the right to have your attorney present during that interview. And number 3, Mr. Harris is going to have to meet with you and go over it, because each side has the right to make sure it's accurate and correct, and then come back and ask for corrections or make objections to the content. You understand, sir?
Yes, Your Honor.
All right, this report will discuss the pretrial agreement, the events, any prior criminal history, score into the guidelines. Please keep in mind that any recommendation it makes is merely a recommendation, as it is the court alone that determines the sentence. And also any score into the guidelines is not mandatory. You understand?
Yes, Your Honor.
Do you have any questions about what we have done today, Mr. Walker?
No, Your Honor, I do not.
Okay, anything further on behalf of the people?
No, Your Honor. Thank you.
Anything further on behalf of the defense?
Your Honor, in light of the plea, we would like to be heard briefly on bond.
Okay, Mr. Carnes, any objection?
But not to being heard, Your Honor.
All right, before you begin, does anyone have an estimated guideline scoring?
0 to 11.
Thank you. All right, and what's his prior criminal history? I'm going to jump the gun. I know what you're going to.
Go ahead.
Yes, Your Honor. If you may give me a moment to pull it up here.
I'm sorry.
Your Honor, there appear to be some theft-related juvenile adjudications, and then, or I'm sorry, just one. And then retail fraud as an adult in 2016, retail fraud 3rd degree. Malicious destruction of personal property in less than 200 in 2020. A disorderly person drunk arising out of that same occurrence in 2020. Carrying a concealed weapon in 2020. Domestic violence in 2022. Another, I can never tell if this is a duplicate or.
Any prior drug charges? I assume so.
There's not a.
No, I'm sorry, no, because there wasn't a second. So, all right, thank you.
No.
Go ahead, Mr. Harrison.
All of which I was going to mention. Now, I do want to, I think it's wise to consider this issue in this context as well, Your Honor. There is an issue with his bond in this case. He did have a period of time where he wasn't, I guess you would call it an absconder status, and was recently returned to jail. That notwithstanding, Your Honor, that is why we didn't have a Killebrew before you today with regard to 7411. Mr. Carnes exercised his discretion and full obligation and right to exclude that from the offer. It was originally part of the offer. After the bond business, I don't take issue with the fact that he did so. I just want to point that out to the court. Otherwise, as the court is probably noting right now, he would be eligible for 7411, and we do intend to ask for 7411 on this case. Given that fact, with the very low guideline and the limited criminal history that you just heard, I would respectfully ask for a release on PR, despite the fact that we acknowledge there was an issue with his bond and he was missing in action for a period of time up until very recently.
Right.
Thank you.
Go ahead.
Thank you, Your Honor. I don't know the exact date, but defendant he was arrested on this on July 11th. And then I think bonded out shortly after his bond was reduced on or around July 22nd. He did okay on bond for a while, and then on August 25th and September 2nd, he failed to appear for 2 drug tests as ordered, and also failed to appear at the, looks like the August 7th, 2025 pre-trial. He failed to appear at that. So I'm concerned about defendant absconding. I think a cleaning out period pending sentencing would be best for all parties. And I'd ask the court to revoke bond at this time. Thank you.
Mr. Harrison, I recognize that the defendant can still request 7411.
Right.
As you know, I generally have a tendency of approving it. I'll not make any.
No, we acknowledge that, Your Honor. We do acknowledge that.
Yeah, but hold on. Whether or not I still will, is still very much open. However, at this time, I'm going to deny the bond modification. We'll be back here for sentencing. Then you can raise that request at that time. Thank you very much, Roger.
Thank you.